Hello my dear friends and welcome to StudyIQ. I am Joycey Joy and today in this lecture we will discuss about the increase in the number of Supreme Court judges in India. So first let us come to the current affair. Let us see what is the current affair. The Union Cabinet has approved a proposal to increase the number of judges in the Supreme Court of India, and following the approval by the Union Cabinet, Parliament has also approved the proposal of the Union Cabinet. So this increase in the number of judges was taken in the backdrop of increasing number of cases in India and also the pending backlog in Indian judiciary. So from this context, the Union Cabinet first approved this proposal and Parliament has given a note for this proposal. So with this, the number of judges in the Supreme Court will be increased. Now, before we move on to this issue in detail, let us first understand about the appointment of the Supreme Court judges. What is the procedure of appointment of the Supreme Court judges? So, in case of appointment to the Supreme Court as a judge, the judges of the Supreme Court are appointed by the President of India. So the President of India appoints the Supreme Court judges, and the CJI, that is the Chief Justice of India, who is the senior most judge among all the Supreme Court judges. The CJI is appointed by the President after the consultation with other judges of the Supreme Court, and also in case if it is necessary that any of the high courts or high court judges needs to be consulted, then the President will also consult the concerned high court judges and all the other Supreme Court judges before making the appointment of a particular judge as the CJI or the Chief Justice of India. Now, what is important to be remembered here is that the CJI or the Chief Justice of India is the senior most judge among all the Supreme Court judges, among all the other Supreme Court judges. Now, regarding other judges, apart from the CJI, the other judges are appointed by the President after consultation with the CJI and other judges of the Supreme Court and the other judges in the High Court. For example, if a particular judge is elevated to the rank of a Supreme Court judge from a particular state High Court, then the state High Court will be consulted, or the judges in that particular High Court would be consulted. So that is why the President makes appointment of a person, of a judge as a Supreme Court judge after making consultations with CJI, other judges and also the judges in the High Court if necessary. So this is regarding the appointment of Supreme Court judges. Now let us come to the proposal of the Cabinet in increasing the number of Supreme Court judges. Now at present the number of judges is 30. This is excluding the CJI. So CJI plus other judges would be 31. That is 30 other judges and the CJI. Now, it is according to the Supreme Court Number of Judges Act in the year 1956 that the number of judges in the Supreme Court is decided. So, this is according to this act. Now, this act was amended the last time in 2009. So, in 2009, the particular act, that is the Supreme Court, the Number of Judges Act of 1956, was amended to increase the strength from 25 to 30. Excluding the CJI. So it is understood that from time to time the Parliament can amend this in order to increase the number of judges to meet the present requirements. So earlier in 2009 it was amended to increase from 25 to 30. Now once the bill to increase the number of judges gets the parliamentary note, that is, now it has got the parliamentary note. So what will happen after the parliamentary note? The number of judges will go up to 33 excluding the CJI. So now this proposal of the Union Cabinet has already got the parliament note. So it means that the number of judges in the Supreme Court will increase from 30 to 33. Now, why this is a welcome proposal or why this is considered as a very important proposal? The reason is that the number of cases in the Supreme Court, the backlog is increasing, and secondly, the CJI itself highlighted that there is a shortage of judges in the Supreme Court. So these are the two important reasons. Now, if we analyze these reasons in detail, first we will see that it was last amended in 2009. So from 2009 to 2019, the nature of cases in India has undergone changes, and also the number of cases has also undergone significant increase. So considering these two factors, there is a requirement to appoint more number of judges in order to look into the cases. Now secondly, the CJI himself has made a comment that there is a shortage of judges in the Supreme Court, and this has posed a problem or a delay in dealing with the constitutional cases. So in case of many constitutional cases, we see that there is a delay in giving the judgment. This is because there is a shortage of judges, and when dealing with the constitutional cases or while interpreting the constitution, it is very much important that even much time is dedicated for this, and also the judges has to study all the provisions in detail. So for that, time is also required. So with lesser number of judges and more time involved in each case, especially with regard to interpretation of constitution, there is a shortage, and Supreme Court is not able to meet all the requirements, or with the available resources it is not easy to settle all the cases or to give verdict for all the cases. So these are the two reasons and why this is a welcome proposal. Now let us also understand, is this only enough in order to increase the efficiency of the Supreme Court, or in that case any other court in India? Is it only enough that the number of judges be increased, or should there be some other measures also? For that, we need to understand what are the other issues pending, or what are the other issues concerned with Indian judiciary along with the scarcity of judges. The first one is that most of the High Court decisions are overseen or are interpreted again by the Supreme Court. So this is also making a delay or time consumption with regard to understanding and studying the High Court decisions of various state High Courts. So for that also the Supreme Court and the Supreme Court judges are dedicating so much time. So whenever it is not necessary, the Supreme Court should not interfere in the decisions of the High Court. And whenever there is a constitutional provision, or whenever there is a case of interpretation of constitution, then the Supreme Court can involve. Otherwise, the Supreme Court should not involve or interfere in all the decisions of the other High Courts. That is the first thing. Second thing is that with the available number of judges, that is with the available resources, the Supreme Court should make maximum utilization. That is, with the available number of judges, Supreme Court should try to see as many cases as possible and also settle these cases. Third one is the PIL or public interest litigation. These days we see that the Supreme Court is handling a lot of PIL cases. So when Supreme Court takes up a PIL or public interest litigation, what really happens is that the Supreme Court will have to keep aside all other cases, whether it is constitutional cases or whether it is any cases related to the issues between the center and the states or between two states. All other important and significant, or we can say strategically important cases are set aside when the Supreme Court deals with the PIL. And these days there are increased number of PIL coming up or piling up in the Supreme Court. So Supreme Court should also take necessary measures to deal with these PIL or public interest litigation, and it should really prioritize PIL and other cases. So most important PILs can be handled, but at the same time those of less relevance, it should be kept aside or kept as a secondary concern for the Supreme Court, or other necessary measures to deal with it should be established. So this is another thing. And the fourth one is the increasing judicial activism. So judicial activism refers to the involvement of judiciary where the jurisdiction is with the legislature or with the executive. We know that there are three organs for our government. The first one is the judiciary, second one is the executive, and the third one is the legislature. So each of these organs, even though they do not have a watertight separation, still they have their own jurisdictions, they have their own functions to perform, they have their own rules to enact. So these days what we see is that judiciary is overtaking the roles and functions of the legislature or the executive, which is often referred as judicial activism, or the involvement of judiciary in those jurisdictions which are for the executive and the legislature. So the increased judicial activism is also consuming the time of the judiciary, especially the Supreme Court. For example, in case of natural disasters or in case of mismanagement of environment, in all these cases we see that the judiciary itself is coming out with rules, guidelines and legislations. So Supreme Court can recommend, or Supreme Court can ask the legislature or executive to enact policies or guidelines, but instead what we see is that the Supreme Court or the judiciary itself is taking up the responsibility of issuing guidelines or issuing rules and regulations for all these. So this is often referred as judicial activism, which is also consuming a lot of time of the Supreme Court, and which leads to again piling up of cases and increasing backlogs in the Indian judiciary, especially at the apex court, that is in the Supreme Court. So these are all some of the other issues that are associated with the functioning of the Supreme Court. And apart from all these, there is a reduced confidence of the public in Indian judiciary, and transparency issues all are there, but these are all some of the other technical issues with the judicial system. So these also must be resolved. Merely increasing the number of judges in the Supreme Court will not be a solution for all these issues. Increasing number of judges is the necessity, is also very important for the present context, that is the number of increasing cases, but along with that all these issues needs to be resolved. So increasing number of PILs should be handled, and the judicial activism should be regulated. Now the overreach of Supreme Court in the High Court decisions should be reduced, and Supreme Court also should be able to utilize the available resources or the available judges capacity. So these all should go hand in hand. Merely increasing the number of judges will not be a solution for the increasing number of cases or increasing backlog in the Supreme Court. Now, what are the other steps that are required in order to make Indian judiciary more efficient and active? The first one would be a restraint on the duration of oral arguments. This is because when the Supreme Court takes up a particular case or a particular issue, then the arguments related to that case goes for many sittings or many times. So this is really creating a backlog. This is because there is no end to a particular case. So Supreme Court should itself dedicate a particular timeline in order to resolve an issue or to come up with a verdict. It should not go for years and years. So at present what happens in Supreme Court is that many cases are pending in the Supreme Court, or the hearing is pending in the Supreme Court, or it's continuing in the Supreme Court for many years. So this should not happen. So there should be a restraint or a particular time limit on the duration of the oral arguments that take place in the court. Second one is to preserve the role of Supreme Court as an interpreter of the Constitution. So the primary role of Supreme Court is to interpret the Constitution, because it is the custodian of Constitution. So in this primary role, the Supreme Court is responsible for interpreting the Constitution in any of the issues where the question of Constitution or any question regarding the interpretation of Constitution is involved. So this is the primary role of Supreme Court. So Supreme Court should preserve this primary role. This is in the sense that the primary importance or the most important priority that the Supreme Court should dedicate to itself should be to interpret the Constitution wherever there is a dilemma or wherever there is a question of involvement of the Constitution. So this primary role should be maintained and preserved. And this also includes the point that other issues, for example, considering public interest litigations or judicial activism, all this should be given lesser priority, and the most important priority should be on interpreting the Constitution. This is because many constitutional cases are pending with the Supreme Court. Even before considering these constitutional cases, the Supreme Court is dedicating itself for many other cases like the PIL, or in order to overreach the legislature and the executive, etc. So the primary role should be preserved. And thirdly, according to the Law Commission report of 229th report of the Law Commission, various suggestions were given. The first one is that a constitutional bench should be constituted in New Delhi also. So this will speed up the dealing with the constitutional cases. Now again, 4 cassation benches should be set for different regions in the country. This can be at the 4 regions. For example, one in the north, one in south, one in the east, and one in the west. So 4 cassation benches for different regions of the country can also be established. And these cassation courts can be the final courts or final appellate courts for routine litigation. For normal cases or normal litigation, these cassation courts can act as final appellate court, so that no more normal cases or normal litigations, ordinary litigations will not reach the Supreme Court. This will reduce the backlog in the Supreme Court. So the time taken for the disposal of the cases will come down, and also this will ensure that there is more access to justice. This is because Supreme Court is established in New Delhi, and for the final appeal, citizens will have to move to New Delhi or will have to travel to New Delhi. Now, if 4 regional courts of such nature is set up where the final appellate or final appeal can be heard, then this will increase the access to justice as well. So these were the 2 recommendations given by the Law Commission. The first one was to establish 1 constitutional bench in Delhi, and second one 4 cassation benches in 4 different regions of the country. So these recommendations are also very important in the context of reducing the backlog of Supreme Court. And merely increasing the number of judges will not be enough, but this is definitely a welcome step. And along with that, all other steps can be taken in order to increase the efficiency and effectiveness of Indian judiciary. You can find the PDF of this lecture on our website www.studyiq.com. You can also follow my Facebook page for more video updates. You can also write to me at joycey.studyiq@gmail.com for any of your queries and clarifications. Thank you.